Listen. Pull up a chair. Light a candle for Celeste Rivas Hernandez, because what I am about to walk you through is the strangest 30 seconds of courtroom footage that has surfaced from the entire David Anthony Burke case file. And I do not say that lightly. 30 seconds. That is how long it took for a real breathing human being, a person whose face the public has never seen, whose name the public has never been told, to walk into a Los Angeles courtroom, sit in the front row of the gallery directly behind the prosecution table, hand a sealed envelope to a sheriff's deputy, and walk back out without ever once turning their face toward a single camera lens. 30 seconds. And the sketch artist, the same sketch artist who has been seated in that courtroom for every single hearing since this case opened, reportedly did not draw them, did not even attempt it. Pencil down. Eyes forward. Pages blank. Because the sketch artist was reportedly told, before that hearing even began, that one specific seat in that gallery was strictly off-limits. That seat, fam, has a name on it. That name in the official records is witness number 7. And before I take you any further into what reportedly went down inside that courtroom, you need to understand exactly what a sealed witness designation actually is, because the internet is throwing that phrase around like it is decorative, and I promise you it is not decorative. It is structural. It is procedural. It is the kind of designation that does not get assigned casually, and the fact that it has been assigned at all, let alone assigned 7 times in a single case file, is the entire reason I am sitting here talking to you tonight. Here is the framework. In California, when a prosecutor reasonably believes that disclosing the identity of a witness, before that witness has testified, before that witness has been formally placed under protection, would create a credible threat to that witness's safety, or to the integrity of the prosecution itself, the prosecutor can file a protective order request under Penal Code Section 1054.7. The court then designates that witness on the official witness list under a number. Just a number. No name. No date of birth. No occupation. Just witness number whatever. And the David Anthony Burke witness list, reportedly, has 7 such designations on it. 7. On a single witness list. That, fam, is not normal. The average sealed witness count on a high-profile California murder case, according to attorneys who have practiced in that jurisdiction for decades, is 2. Sometimes 3. Almost never 4. 7 means the prosecution is reportedly running a parallel protective architecture around David Anthony Burke that we have not seen at this scale in California since the federal organized crime trials of the late 2010s. 7 means someone is reportedly very, very nervous, and the someone who is nervous is not necessarily one of the witnesses. The someone who is nervous might be the prosecutor herself. So let me walk you through what reportedly happened at the last status hearing in the David Anthony Burke case, because this is where the story stops being abstract and starts being something the audience can see in their mind. The hearing itself was, by every public-facing measure, unremarkable. Procedural. The defense filed 2 motions, one of them a motion to compel disclosure of additional discovery, the other a motion regarding the placement of certain exhibits, and the prosecution filed a response to one of them. The judge calendared the next evidentiary hearing for a date that I am going to name in a moment because the date matters, and because the date is closer than most of the case-following community realizes. But 37 minutes into that otherwise unremarkable hearing, a side door at the rear of the gallery, a door that the press pool reportedly did not even know existed because it had been sealed off behind a velvet stanchion rope since the very first hearing in this case, quietly opened. A figure walked through. Court reporters present in the room described the figure as wearing a dark coat, dark slacks, dark shoes, and a face covering of a kind that is permissible under the courthouse's standing medical accommodation policy. The figure walked the short distance to the front row of the public gallery, sat down in a seat directly behind the prosecution table, and did not speak, did not move, did not acknowledge a single person in that room for the next 8 minutes. And then, and this is the part that has the entire case-following community refreshing the docket every 12 minutes, that figure stood up, walked the 4 short steps to the sheriff's deputy stationed at the bar, handed over a manila envelope sealed with what observers in the gallery described as a court-issued tamper evidence strip, and walked back out the same side door they came in through. 8 minutes in the gallery, 30 seconds at the bar. No name announced. No face visible. No press scrum waiting in the hallway, because the press pool reportedly did not even know that side door existed. And the official docket entry for that hearing, pull it up right now on your phone if you do not believe me, contains a 1-line annotation that reads, and I am quoting now, item received from designated party under PC 1054.7, placed under seal. End quote. 18 words. 1 docket line. And every single person in the case-following community who saw that line knew within minutes that something extraordinary had just been entered into the record. The internet found that line within 48 hours. the internet, fam, has been building a theory ever since. And the theory has split, like every good case community theory does, into 3 distinct buckets. So let me walk you through all 3, and let me be exceptionally clear before I begin. Every single category and characterization I am about to lay out falls strictly under the alleged umbrella. No name has been publicly attached to any of these buckets. No one has been charged with anything by the act of walking into that courtroom. And I am not the channel that is going to put an uncharged person's name into circulation before a court does it first. We deal in buckets. We deal in patterns. We deal in receipts, and we deal in procedure. Are you tracking this, fam? Here we go. Bucket 1. The juvenile survivor witness. This is the bucket the larger online case following community gravitated to first, almost reflexively, and I understand why. Reportedly, the prosecution has been quietly building a parallel evidentiary track around a young person, not a minor in the legal sense at this exact moment, but reportedly a person who was a minor at the time of the events under investigation, who reportedly came forward through a youth victim advocacy intermediary in the weeks following the initial identification of Celeste Rivas Hernandez. That witness reportedly does not appear on any public filing because California's juvenile victim sealing rules are reportedly being invoked, even though the witness has since aged out of formal minority status, because the underlying conduct under investigation occurred during that period of minority, and the sealing protection follows the conduct, not the calendar. The Bucket 1 theory holds, in short, that witness number 7 is that survivor. And the envelope handed to the deputy in that 30-second sequence was reportedly a sworn affidavit, executed under penalty of perjury, attaching to a forthcoming amended charging document that would expand the scope of the allegations against David Anthony Burke beyond what is currently on the public record. Bucket 2. The corrections officer. And yes, fam, I am talking about the same officer whose name has been circulating in connection with the photograph of the mattress paper that broke this case wide open several weeks ago. Reportedly, that corrections officer formally entered a whistleblower agreement with the Los Angeles County District Attorney's Office in the weeks following the identification of Celeste Rivas Hernandez, and reportedly that officer is now operating under a protective order of their own, separate from, and in addition to any witness list designation. The Bucket 2 theory holds that witness number 7 is that corrections officer. And the envelope handed to the deputy in that 30-second sequence was reportedly a supplemental inventory, a documented list of additional photographs taken inside the cell that have not yet been entered into the public evidence log, and that may, depending on their content, expand the prosecution's narrative in ways that the defense team for David Anthony Burke has not yet had an opportunity to prepare for. Bucket 3. The forensic auditor. And this, fam, is the bucket that nobody in the larger online conversation is talking about loud enough, and that is exactly why I am going to talk about it loud enough tonight, because this is the bucket where the David Anthony Burke case stops being purely about one defendant and one victim and starts being about a financial institutional structure that may have reportedly surrounded both. Reportedly, the LADA's office has been quietly engaging the services of a forensic accounting contractor, whose name has reportedly never been entered into a single publicly accessible exhibit in this case, and who has been tracing asset movements connected to a particular document production request involving Colleen Burke, as well as, reportedly, several adjacent legal entities and accounts that have not yet been named in any public proceeding. The Bucket 3 theory holds that witness number 7 is that forensic auditor. And the envelope handed to the deputy was reportedly a preliminary findings memorandum that, once formally adopted into the record by the presiding judge, would unlock a second wave of subpoenas reportedly aimed not at individuals at all, but at institutional recipients with potential financial entanglements. So now let me do what we do on this channel and apply some clean procedural logic, because 3 buckets do not stay 3 buckets once you start running them against what we actually know about the operational reality of Los Angeles courtroom logistics in 2026. Bucket 1, the juvenile survivor, has a problem. The problem, very simply, is that protected juvenile survivors in the California system are reportedly almost never physically brought into open court for the narrow procedural purpose of handing an envelope to a deputy. They are deposed instead in protected video chambers. Their sworn statements are filed electronically through their attorneys of record. Their physical appearances, when they occur, are scheduled around closed-door procedural windows and reportedly never involve a public gallery walk-in. The physical walk-in is reportedly not standard juvenile survivor protocol in any major California jurisdiction I have been able to find precedent for. So Bucket 1, in my read, drops to the bottom of the probability ladder. It does not vanish, but it falls. Bucket 2, the corrections officer, has a different problem, and it is a procedural one. The corrections officer is reportedly already a public figure within the docket of this case. Their materials have reportedly already been entered. The whistleblower agreement they reportedly signed has reportedly already been logged. Any new envelope from that officer, in my read, would reportedly be entered through their attorney's electronic filing portal, the standard channel for represented witnesses, rather than via a physical gallery walk-in conducted in person by the witness themselves. Bucket 2 in my read drops to the middle. It is more probable than Bucket 1. It is less probable than what comes next. Which leaves us with Bucket 3, the forensic auditor. And the forensic auditor, reportedly, would be precisely the kind of professional witness who would in fact physically appear in a courtroom, deliver a sealed preliminary findings memorandum in person, and walk back out without speaking to a single soul in the room, because their work product reportedly is so procedurally sensitive that even their identity as a contractor of the district attorney's office is reportedly protected under the same evidentiary shield that protects the witnesses. They have been hired to corroborate. Now sit with this for a second, because in my read, and I want to be careful here because we are working with reported information and procedural inference, witness number 7 in the David Anthony Burke matter is reportedly the forensic auditor. And if that read holds fam, then this case is reportedly about to escalate into a financial institutional indictment track that nobody, not the defense, not the press, not even the most plugged-in case-following community members on the internet, has fully priced in yet. And the timing of when that track surfaces publicly is reportedly measured in days, not weeks. Are you tracking this, fam? Because I need you tracking this. Let me back up for a second and talk about why a forensic auditor would even be part of this case to begin with, because I have seen some confusion in the comment sections about that exact question. When a high-profile homicide prosecution begins to expand, when investigators begin to pull on threads that suggest the conduct under investigation did not happen in a vacuum, that the conduct may have been enabled, financed, concealed, or ensured by parties other than the named defendant, the prosecution will reportedly bring in a forensic accountant whose job is to trace the money. Not the conduct. The money. Where did the assets connected to the named defendant come from? Where did they go? Were any of them moved in the weeks preceding the conduct? Were any of them moved in the weeks following the conduct? Were any of them moved through entities whose corporate filings do not match their banking patterns? That is what a forensic auditor does. That is what the LADA's office reportedly brought one in to do in the David Anthony Burke matter. And the timing is everything. Because reportedly, the engagement of the forensic auditor predates the discovery of Celeste Rivas Hernandez. Read that sentence again. The forensic accounting work in the David Anthony Burke case was reportedly already underway before the body was found. Which means, if that timeline holds, that there was reportedly already a financial investigation track running parallel to the homicide investigation, possibly originating from an entirely separate predicate that has not yet been disclosed in any public filing, and that the homicide investigation, when it did surface in September of 2025, reportedly merged into the financial investigation track, rather than the other way around. And here is the part that nobody in the larger conversation is saying out loud. If the homicide investigation merged into a pre-existing financial investigation track, then the central question of this case is no longer just, how did David Anthony Burke come to be charged in the death of Celeste Rivas Hernandez? The central question is also, what was the financial investigation track that was already running before her body was found, and who else is inside the perimeter of that track? Because, fam, if you are a person whose name appears anywhere inside the perimeter of that pre-existing financial investigation track, then the document that witness number 7 reportedly handed to that sheriff's deputy is reportedly the document that decides whether your name moves from inside the perimeter to inside the indictment. That, fam, is what is reportedly happening in this case right now. And that is the part that nobody is fully reckoning with. Let me walk you through the procedural sequence of what happens next, because the next 48 to 72 hours of this case are reportedly going to be among the most consequential of the entire prosecution to date, and I want you to know what to watch for so that when it happens you are not surprised. You are informed. The next evidentiary hearing in the David Anthony Burke matter is reportedly scheduled in a window that is, as I said, days away, not weeks. And on that hearing date, the contents of the sealed envelope handed by witness number 7 are reportedly going to be handled in one of two ways. Either the envelope is going to be unsealed in open court, with the contents read into the public record under the judge's discretion, or the envelope is going to be moved into a protective order chamber for in-camera review. Meaning the judge reads it privately, the defense reads it privately, the prosecution reads it privately, and the public reads nothing. Either outcome triggers a docket entry. Either outcome moves the case forward. And either outcome reportedly brings us within hours not days, of knowing what witness number 7 actually delivered into the record. Here is what I am watching for on the docket. I am watching for any procedural filing under PC 1054.7 in the 72 hours preceding the next hearing. Because if the prosecution intends to argue for further sealing of the envelope's contents, they will reportedly need to file a supplemental protective order request, and that request will reportedly land on the docket in advance of the hearing date. I am watching for any defense motion filed in response to the docket annotation that reads item received from designated party under PC 1054.7, placed under seal. Because the defense team representing David Anthony Burke reportedly cannot simply allow a sealed item to enter the record without some form of procedural challenge, even a pro forma one. I am watching for any in-camera review request, which would signal that the contents of the envelope are sensitive enough that even the formal courtroom is not a sufficient venue for their disclosure. Any one of those three signals, fam, would reportedly confirm that what was inside that envelope was substantive. Not procedural, not ceremonial, but substantive. And substantive, in the context of a case like this one, is the word that changes everything. And here is the second piece I am watching for. The defense team representing David Anthony Burke reportedly has a small window measured, again in days, in which to file what is called a motion for disclosure under California's reciprocal discovery framework. If they file that motion, they are reportedly telling the court that they believe the envelope's contents include exculpatory material that the prosecution would have an obligation to disclose under Brady. If they do not file that motion, they are reportedly telling the court, or at least telling the case-following community, that they believe the envelope contains material that is so adverse to their client that they would rather not draw attention to it. Both decisions are signals. Both decisions reportedly tell us something about what the defense team believes is inside that envelope. And both decisions will be visible on the docket within the next 72 to 96 hours. So drop a comment below right now. Tell me which bucket you are riding with. Tell me whether you believe witness number 7 is the juvenile survivor, the corrections officer, or the forensic auditor. Tell me whether you think the next hearing in the David Anthony Burke matter results in an open court unsealing or an in-camera chamber review. Tell me whether you think the defense files a Brady-flavored motion in the next 72 hours or sits on their hands and lets the document settle into the record without challenge. And tell me, most importantly, what you think is inside that envelope. Because I want to read your theories. I want to know what your read is. And I will be reading those comments tonight. But before we move on, I want to take one more pass through this case with you, because there is a layer to the witness number 7 story that I have not yet laid out, and I do not want to leave that layer on the cutting room floor. That layer is the question of who exactly brokered the appearance. Because reportedly, the sealed witness designation under Penal Code 1054.7 does not just materialize out of the prosecutorial ether. It is reportedly requested by a deputy district attorney, supported by a sworn declaration explaining the basis for the request, evaluated by the presiding judge, and then either granted or denied. Each of those steps reportedly generates a procedural footprint. And in the David Anthony Burke case, reportedly, the sworn declaration supporting the witness number 7 designation was filed by a senior deputy district attorney whose name does appear on the public docket, but only in connection with one other proceeding in the case, and that other proceeding is itself unusual. I am not going to name that deputy district attorney tonight, because their name has not been formally tied to the witness number 7 designation in any public filing, and the footprint I am describing is reportedly a docket inference rather than a confirmed identification. But the inference reportedly suggests that the witness number 7 designation was filed by the same deputy district attorney, who has been handling the financial document production track of the case, not the homicide track. And if that inference holds, fam, then the bucket 3 reading I walked you through earlier is reportedly the reading most consistent with the deputy DA who actually filed the underlying paperwork. Which means the case against David Anthony Burke in the death of Celeste Rivas Hernandez is reportedly the visible piece of a much larger procedural iceberg. And that, fam, is what I keep trying to tell you. This case is not the story. This case is the surface of the story. Now let me come back to Celeste Rivas Hernandez for a moment, because I want to make sure that every single conversation we have on this channel about the David Anthony Burke prosecution begins and ends with her, because she is the entire reason any of us are here. Celeste Rivas Hernandez was 14 years old when the remains of Celeste Rivas Hernandez were identified inside the front trunk of an abandoned Tesla in Los Angeles in September of 2025. 14. The age at which most young people are taking their freshman year photos. The age at which most young people are picking out a homecoming outfit. 14. And the case against the person reportedly responsible for the death of Celeste Rivas Hernandez, the case against David Anthony Burke, has reportedly been building slowly, steadily, procedurally in the months since. And every procedural development, every motion, every hearing, every docket entry, every sealed witness, every envelope handed over in 30 seconds, is reportedly a step closer to justice for Celeste Rivas Hernandez and the family Celeste Rivas Hernandez left behind. So when I tell you to watch the docket, I am telling you that because the docket is the only public-facing surface of a process that, for the family of Celeste Rivas Hernandez, is reportedly the only place where accountability is currently being measured. And if that process is reportedly about to expand, if the architecture I have walked you through tonight is reportedly even close to accurate, then the next 48 to 72 hours are reportedly going to matter more to that family than any single development in this case since the body was found. So keep her name in your mouth. Fam, keep Celeste Rivas Hernandez at the center of every conversation. Do not let her become a hashtag. Do not let her become a thumbnail. Do not let her become the second name in a story about a famous defendant. She is the first name. She is the central name. She is the only name that matters. And let me say one more thing about the figure who walked into that courtroom, because I want to be precise about this and I want to be respectful about it. Whoever witness number 7 actually is, that person reportedly walked into that courtroom knowing that the act of walking into that courtroom would draw attention. They knew the sketch artist had been instructed to put their pencil down. They knew the side door behind the velvet rope had been quietly cleared in advance. They knew the sheriff's deputy at the bar had been briefed on what was coming. They knew that the 8 minutes they sat in that gallery silent, still face covered, would be the only physical presence appearance they would reportedly make in this case until the case reaches the trial phase. They knew all of that. And they walked in anyway. They handed over the envelope anyway. They walked back out anyway. And whatever motivated that person to make that walk reportedly outweighed, in their personal calculus, every single risk that the walk entailed. That is not a casual act. That is not a procedural formality. That is a person reportedly deciding, in the most consequential way available to them under the laws of this state, that the contents of that envelope mattered more than their anonymity. That, fam, is the kind of decision that does not get made unless the person making it believes with a high degree of certainty that what they are handing over is the thing the case turns on. And the next hearing is days away. So let me close with this. There are a lot of people watching this case from the outside. There are a lot of people who, reasonably, have grown numb to procedural developments because most procedural developments do not amount to much. I understand that. I have felt that numbness myself in other cases in other moments. But I am telling you, and I am telling you not as a guess, not as a prediction, but as the procedural read of a case follower who has been watching the David Anthony Burke docket since the day the case opened, that what happens at the next evidentiary hearing in this matter is reportedly going to be one of the inflection points. Not a routine hearing. Not a status conference. An inflection point. The kind of hearing after which the case looks measurably different than it looked before. The kind of hearing after which a new procedural phase begins. The kind of hearing that, 6 months from now, the eventual documentary about this case will reportedly point to as the moment everything started to unlock. And I do not say that lightly. I do not say that for clicks. I do not say that for engagement. I say that because the procedural fingerprints reportedly support it, and because the docket reportedly supports it, and because the 7 sealed witness designations on a single witness list reportedly support it, and because the 30-second walk-in handover that did not generate a press scrum reportedly supports it. Every piece of this reportedly points in the same direction, and the direction it points is reportedly toward an expansion of this case that the larger public conversation has not yet caught up to. So set your notifications. Save the docket bookmark. Refresh it every 12 hours if you have the bandwidth, every 48 hours if you do not. Watch for the procedural signals I told you about, the supplemental protective order request, the defense response motion, the in-camera review request. Watch for new docket annotations referencing PC 1054.7. Watch for the deputy DA whose name keeps surfacing in the financial document track to file anything at all. Each one of those signals is reportedly a tell. Each is reportedly a breadcrumb. And the breadcrumbs reportedly lead somewhere this case has not been before. I am riding with Bucket 3. The forensic auditor. That is my read. That is the procedural inference I am sitting with as of the recording of this episode. I could be wrong. I have been wrong before. But as of right now, in this moment, witness number 7 in my read is the forensic auditor whose preliminary findings memorandum is reportedly about to unlock the second wave subpoena phase of the David Anthony Burke prosecution and reportedly redirect the procedural arc of the case for Celeste Rivas Hernandez. And if that read holds, then the case against David Anthony Burke for the death of Celeste Rivas Hernandez is reportedly about to look very, very different from the case the public has been following since September of 2025. Are you with me on this, fam? Are you riding with Bucket 3, or are you riding with one of the other two? I want to know. I really genuinely want to know, because the case following community on this channel is the smartest case following community on the entire platform, and I have learned more from your comments over the past several months than I have learned from a lot of the legal analysts who get paid to talk about cases like this one on cable news. So drop your read. Drop your bucket. Drop the procedural signal you are personally watching for. And let us argue it out, respectfully and with receipts, in the comments section under this video. Before I sign off, I want to give you one last piece. One last detail. One last breadcrumb to chew on. Because reportedly, and I am underlining the word reportedly here, the manila envelope that witness number 7 handed to the sheriff's deputy in that 30-second walk-in had something on its exterior. A marking. A small one. A symbol that reportedly indicated which prosecutorial track the envelope's contents were associated with, the homicide track, or the financial track. Court observers who reportedly saw the envelope at close range described the marking as a single letter, handwritten in black ink, in the upper right corner of the envelope's front face. I am not going to tell you tonight what letter those observers reported seeing because I want you to come back for the next episode, and I want you to bring your bucket 3 friends with you when you come back. But I will tell you this much. The letter those observers reportedly described is not the letter you would expect to see if the envelope's contents were associated with the homicide track. Sit with that. Carry it with you for the next 48 hours. And when the next docket entry drops, you will have the framework to read it. And one more piece before we land this plane, because I have been getting a question in the comments under the last several uploads, and I want to address it directly tonight. The question is this: why does any of this procedural detail matter to the family of Celeste Rivas Hernandez? Why does it matter whether witness number 7 is a juvenile survivor or a corrections officer or a forensic auditor? Why does it matter whether the envelope contained an affidavit or an inventory or a findings memorandum? Why are we, the case-following community, spending so many hours on procedural inference when the central fact of the case against David Anthony Burke, that 14-year-old Celeste Rivas Hernandez is gone, is already a settled question of public record? Here is my answer to that question, fam, and it is the answer I want every single person in this comment section to sit with. Procedural detail matters because procedural detail is the only thing standing between the family of Celeste Rivas Hernandez and a prosecution that fails. Procedural detail is the architecture of accountability. Procedural detail is the difference between a conviction that holds up on appeal and a conviction that gets overturned 3 years later because a sealed witness was not properly designated or because an envelope was not properly logged. Every single procedural step in the David Anthony Burke case, every sealed designation, every docket annotation, every protective order request, every in-camera review, is reportedly a structural reinforcement of the eventual outcome. And the family of Celeste Rivas Hernandez reportedly deserves an outcome that is structurally sound, not just emotionally satisfying. Structurally sound. The kind of outcome that an appeals court cannot dismantle. The kind of outcome that Celeste Rivas Hernandez, were she able to speak for herself tonight, would reportedly want for the next 14-year-old whose path crosses someone like David Anthony Burke. Because there will be a next 14-year-old. There always is. And the procedural architecture of the David Anthony Burke prosecution is reportedly the thing that determines whether the next 14-year-old gets a system that knows how to protect her. That is why we sit with the procedure, fam. That is why we read the docket. That is why we track witness number 7. Because procedure in cases like this one is reportedly the only language the legal system speaks fluently, and if we want the legal system to speak on behalf of Celeste Rivas Hernandez, we have to learn to speak its language alongside it. And one more procedural piece while we are here, because it has been gnawing at me since the docket annotation first surfaced. The phrase used in that annotation, designated party, is a specific term of art under California sealed witness procedure. It is not interchangeable with witness. A designated party reportedly refers to a person whose identity has been formally registered under a protective order designation, but whose role in the case is broader than pure witness testimony. A pure witness in California procedural language would reportedly be referred to as a protected witness in that docket line. The fact that the annotation reportedly used designated party instead of protected witness is, in my read, another procedural signal that bucket 3, the forensic auditor, is the correct read. Because a forensic auditor is reportedly not strictly a witness in the testimonial sense. A forensic auditor is a designated party whose work product enters the record through a different procedural channel than testimony. And the docket reportedly chose the language that fits that channel. Shout out to the case followers in the comments of the last 3 uploads who flagged that language difference before I did. You saw what the official press corps missed. You read the docket line for what it said and not for what it sounded like. And that is the read that reportedly broke this whole thing open in the smaller corners of the internet days before the larger commentary channels caught up. So here is what I want from you in the next 24 hours. I want you to pull up the public-facing docket of the David Anthony Burke case on the Los Angeles Superior Court portal. I want you to scroll to the most recent procedural filings. I want you to look for the docket entry that contains the phrase, designated party. I want you to screenshot it. I want you to bring it into the comments section under this video. And I want you to tell me what you see, because every set of eyes on that docket is another set of eyes that the family of Celeste Rivas Hernandez reportedly has fighting for them right now. The press is not watching this case the way you are watching this case. The press is reportedly distracted. The press is reportedly under-resourced. The press, in many cases, is reportedly chasing celebrity angles instead of procedural ones. But you fam are reading the docket. You are tracking the sealed witnesses. You are noticing the difference between designated party and protected witness. You are the reason cases like the David Anthony Burke prosecution stay visible long enough for the procedural architecture to do its work on behalf of victims like Celeste Rivas Hernandez. Do not stop watching. Do not stop reading. Do not stop refreshing. I will see you on the docket, fam. I will see you in the comments. Keep Celeste Rivas Hernandez at the center of every conversation, and keep your eyes on the procedural signals I walked you through tonight because they are the only signals that matter right now. The case against David Anthony Burke is reportedly about to move into a phase the public has not yet seen. And when it moves, I will be back here to walk you through it, one docket line at a time, one sealed witness at a time, one 30-second courtroom walk-in at a time. Take care of yourselves. Take care of each other. And remember, every conversation we have about the David Anthony Burke case begins and ends with Celeste Rivas Hernandez, the 14-year-old whose name reportedly should never have left the lips of David Anthony Burke in the first place, and whose name we will be saying for as long as this case stays open. I will talk to you on the next one.